Good afternoon, everyone. We are here with Chris Geidner, founder of Law Dork, the absolute go-to source for what is happening with the Supreme Court. Chris is joining us today, along with Michael Martinez, who is an associate professor at the University of Tennessee School of Journalism and Media. We have a family connection with Chris to UT because his brother also is an associate professor at Tennessee and the School of Journalism and Electronic Media. So much thanks to Nick for getting this set up for us. Michael is going to serve as the moderator of this event. He is an expert in all matters of media law and media and the courts. My name is Maria Cornelius. I'm president of ETSPJ, and I'm going to turn it over to Michael and Chris.
Hey, Chris, welcome.
Hey.
Thanks for coming to speak to us. So what we'd like to do today is talk a little bit about the recent happenings with the Supreme Court and some of the threats, concerns, or I'm not quite sure how to describe it, but First Amendment issues, court access issues, man, a little bit of everything, it seems like. So maybe one of the first things, if we could get started, the court just adopted, I'm using air quotes here, code of ethics. So what does that mean?
Yeah, the air quotes are the most important part of it. We don't yet know exactly what it will mean. So I mean, the background, I'm sure a lot of people know, is that there has been particularly over the past year, a lot of reporting, primarily from ProPublica, but also some important stuff from the Washington Post and New York Times, and some other key developments in other publications across the range, looking at the ethical practices of the justices. And now, the thing is, it might seem totally upended, but the only federal judges who are not subject to the statutory code of conduct and the administration of the federal courts has adopted are the Supreme Court justices. Lower court justices have to follow the code of conduct that has been in place for a long time. Now, looking at a long range, back in 2011, there had been some ethics questions raised about the court, and having to do primarily with Justice Thomas and his friendship with a wealthy gentleman who you might have heard of this year, Harlan Crow. Yes, truly, it going through stories from 2011 will depress you. This was almost the same issue in 2011, and at the end of 2011, the Chief Justice issues an end-of-year report, and John Roberts issued this end-of-year report that focused on ethics. And in large part, he said, "We hear you, we got it, we'll into that." But even though it's not a court opinion, everybody looks into every paragraph, every word that the chief said, and there were some real questionable stuff in there. Like, he noted that the justices have always paid attention to the disclosure requirements, the financial disclosure. He didn't say they were subject to it. He didn't say that it was required. He said that they've always followed it. He explicitly said that the court had never ruled on whether Congress could issue guidelines for the justices. He also said that the justices, I don't want to, this isn't a quote, but he basically said the justices consult. The language that they've used since is consult. I don't know if that's what he used in the end of year report, but that the justices consult the code of conduct that applies to other judges when making their own ethics decisions. But the bottom line is, and it comes important to this year, is that all of the justices are an independent justice. Like this isn't like the president and cabinet members, where as we see on every TV show, I serve at the pleasure of the president. They don't. The associate justices do not serve at the pleasure of John Roberts. They oftentimes serve at the displeasure of John Roberts. They are separately confirmed. They have their own constitutional role. And so when we talk about the court making a decision, oftentimes we only see it through like some administrative like memo from the clerk. But ultimately what it means is, in most cases, the justices unanimously agreed to it, or at the least, there was a majority vote. John Roberts can't just decide, I'm going to do this. And so after this reporting, you also had the Senate Judiciary Committee, which obviously has a Republican House, so they're not expecting to pass any laws this year. But there is legislation that they're considering. They started doing investigations. They started seeking information from some of these outside people. They held hearings, and Chair Dick Durbin said, like, we're going to move forward with this if they're not going to. And we went through a summer, they didn't. In the meantime, this issue of Moore versus United States, a case about the income tax that the justices heard this week, it turned out that one of the lawyers on that case for the Moores, who were asking for this upending of the income tax code, was the lawyer who Sam Alito kept sitting with multiple hour-long off-the-record interviews that became these very glowing, narrative-helping commentary pieces in the Wall Street Journal. David Rivkin Jr. And he is a counsel on this case. He is a lawyer for the Moores. And so a lot of people were like, whether this is a conflict of interest, it certainly has the appearance that you have an inappropriate relationship with these parties. I think a good sign for why all of this matters, why this reporting matters, why this Senate action matters, even if there's no legislation. Sam Alito, who, like, along with Justice Thomas, are like the two justices who like truly believe, like, we owe you no explanation of our behavior. Like, you confirmed us. You can choose not to confirm us if you want. But once that's done, your choice is impeachment. He felt the need to issue a 4-page statement explaining why he wasn't going to recuse himself. Now, I then followed up and wrote a post at Law Dork about why that was a load of malarkey. But I do think it's important. Like, that is not what I would have expected Sam Alito to do. And so then we get to the fall, and finally, with a lot of background fighting going on in the justices, we saw random comments over the summer. I mean, early on from Kagan and the Chief Justice that, like, they expect something's going to happen. Then later on, we even got a statement from Kavanaugh, which sort of suggested to a lot of us that, like, yeah, it really is these two holdouts. Like, it really is. I mean, imagine you all have been in a Google document when there's somebody who keeps offering suggestions after everybody else is done and wants to be done with the document. I think that Alito and Thomas were still offering up some suggested changes. And they finally issued it. And it really is very similar to the code of conduct that lower court judges have to follow. Now, there is no enforcement mechanism. So it truly still is whatever the justices, however they interpret it. And that's the big problem, especially from like the Senate Judiciary's perspective. The other thing is, and people went through, and you can look at some of what I talked about, some of what other people talked about. I don't know if anybody did a pure red line, but there were some changes. Now, some of the changes were what I'd say relate to the fact that the Supreme Court is unique. If somebody recuses themselves from an appeals court decision or a trial, another judge can be appointed. If somebody does that on the Supreme Court, it just means we take down the number by one. There's no, under the current rules, there's no procedure for replacing. Now, some of the legislation would suggest a change that would not require a constitutional change. Well, they don't think it would. I agree with them. And that would be allowing retired justices who have not, who basically have gone senior status. They haven't actually left their judgeship. And they would be able to sit in if a justice is recused. And that is, you might not know it if you're not paying attention to it, but like Justice Souter, Justice Breyer, and Justice O'Connor in recent years did sit on lower court cases after they retired. I don't know if Kennedy has yet, but O'Connor and Souter did regularly. I don't know if Souter still does, but he sat on First Circuit cases and O'Connor sat on Ninth Circuit cases regularly. And so that is one way of dealing with that recusal issue. But a lot of the other changes were things that were sort of questionable, that people were like, that sounds like you wrote in an exception that allows for the very thing that led to ProPublica's reporting. There's a line that was added in about that people said, I thought slightly unfairly, but not completely unfairly, like it was you can do anything with the Federalist Society card. And it's language about like that the inability to like be paid to appear at events doesn't apply to academic or educational, intellectual institutions aimed at an understanding of the law, which was basically the description that the Federalist Society uses in its like, we're a 501c3 forms. And so there's some concerns that the ways in which, even to the extent that this is not enforceable, that this was watered down from what other judges have to do. Some of those waterings down were specific things that had been raised as concerns that people had about the behavior of Justice Thomas in large part, but also Justice Alito. There were also some things, there was an AP report about that did focus on some of Justice Sotomayor's travels relating to her books. And the idea that staff was being used to help set up those travels, and that there were often like, I mean, as is not unusual outside of the court, like there were often like book purchase requirements related to those visits. And so like you can fairly argue that there were court staff being used to help make money for Justice Sotomayor outside of her court salary.
Can I pivot a little bit now?
Yeah.
Can we talk a little bit about the gag orders on President Trump and where I mean, his argument is that it's violating his free speech rights. And the court's arguments are that you're endangering the criminal justice system for one thing, but personnel. So in your opinion, where does this fall? Where
Yeah, the DC Circuit arguments were really interesting, because in some ways, because it was a 3 Democratic appointee panel, and they were very concerned in a way that you might not have seen with other panels, with the implications of with doing what we often talk about, like you're creating. Yes, we've got this situation of this unprecedented Trump trial, although now it's like multiple unprecedented Trump trials. But you also have the fact that, like, especially once you get to an appeals court decision, you're creating law that would apply to anybody who is charged in the DC Circuit. And so there was a lot of discussion at the oral arguments about, like, what rules are we setting for other people? And in some ways, ways that maybe in the reaches of the internet and the anti-Trump internet probably didn't like it, that they were like, he has rights. He's a criminal defendant. And we can't just say that he's not allowed to talk about how he thinks he's getting railroaded. There was a point in the arguments where they were talking about, like, well, what if he participates? He hasn't participated in debates thus far, but what if he did? Would that mean that, like, Nikki Haley is allowed to spend like 5 minutes going after him, calling him a crook, talking about all of the charges, saying, I mean, even like, and the facts were in these hypotheticals the judges were proposing were very carefully tailored to the issue, which is like, what if Nikki Taylor says Jack Smith is a patriot and the special counsel is doing important work and his prosecutors are taking care to see that Donald Trump is held accountable? Under this gag order, does that mean, because court personnel are involved, that Trump would not be allowed to respond to that, even though it was raised in the context of a presidential debate about his fitness for office? And that's a really good question. Like,
well, the thing is, the gag order is very limited, and it specifically focuses on court personnel, not
right. Well, that's what I'm saying. This
court personnel. So if Nikki Haley said the things that you just said, I don't think it would stop Donald Trump from saying, "Oh, it's a railroad," as long as he doesn't impugn the court clerk and so forth. I mean,
it also includes the prosecutors.
Well, but I mean, these people are getting death threats. Their children are being followed home from school. I mean, it's terrible.
I get it.
Yeah.
You're not.
I don't think, as long as Donald Trump keeps his comments to things like, "Oh, I'm being railroaded." Well, this morning, he did what he always does before he made his court presentation, which, by the way, he didn't even have to be in court today. It seemed like the whole purpose was to talk to the cameras for 15 minutes or so before he entered the courtroom. All the points that he was making this morning, that was not under the gag order.
Oh, yeah. And that was a lot of the discussion at the arguments, were that there are lots of things he can say. But that's why, I mean, specifically, Jack Smith is the special counsel. He's the prosecutor. And under the gag order, there are things that he can say about Jack Smith, but not about the line prosecutors. And so that's why the question, like the hypo that they were posing was, what if, I mean, it wouldn't be Nikki Haley in reality, it would be Chris Christie. What if Chris Christie said these lines, I mean, and it would actually fit, he's a former prosecutor. Like, what if Chris Christie said these line prosecutors, he names them, these line prosecutors are doing their constitutional duty, they're doing an important job to keep this man from getting back in office. Under the gag order, he could be held in contempt if he responds to that. So that's the question. That's the issue. I mean, it is this problem of when you have, I mean, and this is my bottom line here, just so y'all know, and I've said this is all the Senate's fault. The Senate should have convicted him in January 2021, and he wouldn't have been able to run for office. This is why in our system, we didn't think we'd have to be asking these questions about all of these questions that Trump's raising in his cases about whether you can try someone after, whether it's double jeopardy to try them criminally after they've been impeached and not convicted, which I think is a bad argument, but it's actually a lot closer argument than people think. The whole idea is that we wouldn't be having this issue if the Senate had acted. And but because they didn't, and we have these criminal trials, we have the issue of not only regular criminal defendants' rights and the fact that these are going to apply to people, but then you have this very core political speech issue of a person who is currently authorized and qualified to run for office, running for office, and are we going to say that if he says certain things in the context of that campaign, he can be jailed? Now, the answer may be yes, as we get closer and closer to causing potential actual harm to court personnel, to line prosecutors. But I think what we're going to see from the DC Circuit is it being narrowed to one step away from incitement. Like, it might be a step beyond incitement, which he could be criminally charged for anyway. But it's going to come awful close to incitement because they're just very worried about making it on both fronts, making it so that a person who hasn't been convicted isn't able to respond fairly to anything that is raised in his campaign by his opponents, and because of the implications for other cases. Oh, you're muted, Dorothy.
Sort of a related topic in that it has to do with Trump. It's not really a First Amendment issue, though. The Supreme Court yesterday heard the case concerning whether he could be kept off the ballot in Colorado, using the argument that I forget the number, but one of the
14th Amendment.
Yeah, the amendment right after the Civil War that was really aimed at those who fought the federal government could not hold office. And of course, the lower court held that apparently every other officer in the United States system is covered by that amendment, but that the president is not. And so the Supreme Court of Colorado heard that argument yesterday, and we'll have to see how they rule. But I wonder if Chris would like to comment on that. I mean, it looks like it, regardless of how the Supreme Court rules, if they rule against Trump, or I think either way they rule, it's probably going to be fast-tracked to the U.S. Supreme Court. And who knows what can happen with that Republican-leaning court.
Yeah, I mean, I think I think it's a fairly clear case. The only question would be whether other officials are able to make the conclusion that someone has violated that provision in the 14th Amendment before a court has adjudged a conviction. So in this case, it would be before Georgia or the DC cases are adjudged. Now, I don't think that you need it. I think that you don't need it by the terms of the amendment. I think the only question would be sort of the implications for the future. The fact that, like, does that mean that a renegade Secretary of State can just invoke this willy-nilly? I don't think so. I think that we have protections like this for when they're needed, and we haven't thought it needed since the Civil War era of post-Civil War would-be office holders left the mound. But I mean, the officer argument is ridiculous. I agree with you there that Josh Blackman, professor, sort of started to pose that after Will Bode and his co-author came out with their law review article that sort of started this ball rolling. People had been talking about it since right after January 6th, more thinking about the implications for members of Congress when there were like these issues about whether members were actively involved. But I think that when it comes to moving up to Trump, this article from Will Bod and his co-author, and I feel really bad that I forget his name, but I've known Will since I was in law school, so that's the way that goes. But they came out with this article that really was like, I think like a 200-page article that delved through it all and made a pretty clear case for why this applies to January 6th and why it applies to Donald Trump. And to be honest, the officer part of their article was very small because they had the reaction that you had, Dorothy. And I think I mean, I think the truth is that the rest of the argument is so solid that even right away from the immediate aftermath, when lots of conservatives were writing in support. I mean, Will is a conservative. He's a University of Chicago law prof, no liberal. And there was a lot of support from conservative law professors to their point, as well as more liberal professors. But Josh Blackman, I don't know if there were other people initially who started pushing this officer line, but they did. And I mean, I honestly think it was a way of the trial court judge in Colorado being able to not be the first one to make the ruling and pushing it off to the Colorado Supreme Court because he knew that's where it was going to go anyway. And so it was easy enough to pick the one thing that there was at least a not facially laughable argument against to not make the ruling themselves and send it up to the Colorado Supreme Court. But I agree it's going to go to the U.S. Supreme Court, and I think it should happen quickly. I'm actually a little upset it's not already there because I really think that it is a question that at the least should be definitively resolved before we get into actual primaries, let alone having him be the presumptive nominee.
Quick thing, Michael's got some more ground to cover, and then we're going to try to leave time for questions at the end. I know Michael's got some other topics, so Michael, I'll let you move forward.
Okay, I wanted to ask a little bit about Dobbs v. Jackson. I mean, on the surface right off the bat, is it strikes down Roe v. Wade as unconstitutional, but underlining that in the argument is it was all based on privacy in the first place. So what else is under threat, do you think?
Well, I would argue, I would actually push back on that pretty strongly because Sam Alito said so. Alito's opinion made clear that it was not just about privacy, that there were other bases for the decision, that it did have to do with the unique position of abortion, and specifically said multiple places that it does not affect other substantive due process rights. Now, of course, that doesn't mean that lower court lawyers aren't going to argue it. I think you all in Tennessee have seen one of the clearest areas where they have, which is this area of I can never say the name right, even though a professor constantly tells me it. Guldidig. It was a 1970s case having to do with California treating not allowing pregnancy related claims under their disability, and the Supreme Court said that that it was not a type of sex discrimination. There was a paragraph in the Dobbs ruling that very dismissively, it was really poorly handled, even for Alito standards. It had not been debated in arguments. It had not been heavily discussed, but there has been throughout time an argument that abortion bans are sex discrimination. Both on the front side of who they're targeting and on the back side of the impact, the disparate impact of those bans. And he sort of dismissed those in a paragraph and sort of cited to this 73 case, like we've said that, like, if there's something that happens to only affect one sex and the state does something, but they're not doing it because of the sex, we're not going to consider that sex discrimination. And there is a question outside of substantive due process, outside of privacy, which is the stuff that was affirmatively cabined because of the potential for life, these countervailing interests about the state's interest in the protection of the fetus, all of this that they used in the opinion to differentiate that privacy right from other privacy rights. This sex discrimination paragraph has been picked up and was used most prominently in the gender affirming care ban cases. It was used in the both Tennessee and Kentucky used it in their cases, as did Judge Sutton in his opinion, upholding the bans. And what they're doing is saying gender affirming care bans are, which pretty much all courts across the country, trial courts, district courts, hearing cases, hearing evidence, hearing the experts, have said is a type of sex discrimination, both on its face, sex discrimination, and on the basis of transgender status. But on the sex discrimination point, what Sutton said is applied that and said basically Dobbs has breathed new life into that 1973 decision, which the important thing to understand is that 1973 decision was before any of the sex discrimination cases that we know as the law today. All of Justice Ginsburg's work, basically, both as a lawyer and then as a justice, and sort of the heightened scrutiny that like still applies from like the VMI case, that there's no there was no, it wasn't necessary in the Dobbs case because it was really a side point. They weren't considering the issue, but it has now been picked up and is sort of like, now we can use that. And it's allowing courts that use it to sort of say that this was talking about the medical context. So because these treatments are being banned for children, for all children, even though it's different treatments for trans boys and trans girls, that we're going to say that this isn't sex discrimination. And we're allowed to do that under Gültig as now alive again because of Dobbs.
Yeah. In Clarence Thomas's concurrence, though, didn't he kind of push back against Alito, saying, well, maybe?
I mean, he did, but when you're a one justice dissent, I mean, that was a dissent in that,
right.
On that note, because of the fact that I mean, he was concurring because he agreed with the decision.
Right.
But as to that point, that was actually dissenting because the Alito's opinion said explicitly that that is not affected. Certainly, the three dissenters agreed it's not affected. Kavanaugh's opinion was attempting to express instances in which Dobbs would not lead to bad things, including travel, including these other things. So he's on board with that. So, I mean, really, I think if Thomas can't even get Alito to say something, like you're not going anywhere with it.
Right.
So could somebody raise the question in some court, I mean, in Northern District of Texas, and get Matt Kaczmarek to do something that the Fifth Circuit then allows, that then forces the Supreme Court to deal with it? Yes, it's possible. I don't think that, I think the court has bigger fish to fry. And I think that even in those areas where we're seeing these particularly new laws being passed, I think that there's a lot more, there will be much more central litigation that is more likely to cause harm, that doesn't need to even overturn past precedent in order to do it. And I'm thinking like the sort of fallout, like in addition to the new laws, but like fallout from 303 Creative last term, with the website maker who didn't want to make websites for same-sex couples marriages.
Right.
I think we're more likely to see expansions of exceptions than some wholesale overturning. Now that could mean, like, if things keep going in what I would say is a bad direction, that could mean you could argue that's what happened with Roe, that Casey
50 years, but yeah,
was reaffirming Roe, but it did narrow it slightly and allow states to do more. And then you had you had 20 years, 30 years of cases slowly teetering around the edges, and then you eventually got a court that was willing to overturn it. So by that logic, like, you could argue that 303 Creative is like the harbinger of a 2055 decision overturning Obergefell.
Well, you know, in part of the reason I asked about Clarence Thomas, and Gorsuch is kind of joining this too, and Scalia did when he was alive, is coming back to New York Times versus Sullivan, and some of the things that we have, from the free press standpoint, consider landmark decisions. It seems like recently, with the shifting of the court to a more conservative stance, that Clarence Thomas has gotten his voice all of a sudden.
He has on a lot of cases, but I would say on New York Times versus Sullivan, we keep seeing him just like still like writing what he wants and not really able to muster people wanting to delve into it. I mean, that's definitely something that I would put like on a list of high concerns in a second Trump administration. If you do get some, I mean, now ironically, actually, that would be sort of like, I don't know if you remember, like during the end of the Obama administration, when Garland was nominated, there were some criminal justice advocates who said, you know, I would rather have Scalia than Garland on the court. That for criminal justice issues, they were like, yeah, on balance, fine, I'll take the loss, and we can get Garland to get rid of Scalia. But but I would have rather had Scalia on the court for criminal justice issues than Garland. He was, I mean, was and still is, now is the nation's top prosecutor. He had been a not liberal criminal justice advocate on the DC circuit. He obviously is one of the few federal officials to put someone to oversee the prosecution of somebody who was put to death with Timothy McVeigh. And so there were some concerns about that. I think you would have the same thing with, if you're one of those advocates of overturning New York Times versus Sullivan, it is very, I mean, Thomas is the oldest justice. He's the most likely to retire or leave the bench through no will of his own, if there is a vacancy. And if you picked a conservative judge out of a hat, even a judge that Trump wants, even knowing that Trump would love New York Times versus Sullivan to be overturned, it's sort of that, like, any of you who study like polling and like when you get that question that like gets 80% of people say they care about something, and that's what's used by people, and then you ask people how highly they care about it, and it's like the 12th thing on their list. And so they're never going to vote on it. I think it's the same thing with choosing a justice. You're never going to have a justice picked because they want to overturn New York Times versus Sullivan. So you could end up actually like getting a more secure New York Times versus Sullivan if and when Thomas leaves the court. Although you could get some young firebrand who has written an article about why it needs to go. But I do think that that's one that, I mean, it's not even unintended consequences. It's one that there's so many clear, dramatic consequences that, I mean, certainly, the chief and Kavanaugh and Barrett aren't going to want to weigh into that.
That's good to know, or surmise. I saw on your Law Dork around Thanksgiving that you noticed that the justices were a little more collegial or fun-loving. Is there contention in general in this court that didn't exist before?
I mean, yes. I mean, I think there was. I think that, I mean, honestly, it's hard to diagnose the patient with the Supreme Court, because so much of what's happening is happening behind the scenes, and so much of what's happening is secret. And so you really have, it's one of the reasons why I think that attending oral arguments is so important. It's one of the reasons why I think that oral arguments should be televised. I think it is one of our only opportunities to see the justices interacting with one another, even though they're technically doing so through the lawyer before the court at the moment. And I think there are a couple of things. I think one, like you all, at least on camera, are of an age that we remember this era, that from the time that Clinton appointees got done, by the time Breyer and Ginsburg were on the bench, from when Breyer got on, there were no changes to the makeup of the court until Justice O'Connor announced her retirement.
Right.
That was a long time. Now, they did have a huge upheaval in the middle with Bush v. Gore, but from 93 to 2005, there was no change in the court. And that was, I think, the longest time since, for like almost 100 years. And so that was a very stable court. We have not had that since. We have not had that since. We've had one or two changes every 2-3 years since then. And it's really important to know, to not just know, because we all know it like on the surface, to take in the fact that like the Supreme Court, I often describe it as like not the Titanic, but a big ocean liner that has 9 captains, and it can't do anything unless 5 of them agree. And when it does something, it's gonna be slow. Like it's gonna be slow. Like, I mean, even if you think about Dobbs, like we can say that happened overnight, but we all know it actually really started when they refused to stop the enforcement of Texas's SB 8 in September. Because that was clearly unconstitutional under Roe and under Casey, and they allowed it to go into effect. Now, whether it was because of this weird enforcement proceedings, whatever like rationale they used, we all knew it was an unconstitutional law, and they let it go into effect. And a lot of people said like that was the actual night that Roe was overturned. When they had even let the law go into effect without an opinion for 24 hours. Then they had the decision. Then we started having the follow-up. Now I've written this week about the fact that right now, tomorrow, the justices are going to be considering whether to take one of these medication abortion cases. They are considering a stay application from Idaho relating to a challenge from the Biden administration under EMTALA, the emergency room care law, where they said that because of Idaho's near total abortion ban, that in some small instances it would conflict with EMTALA, so you need to have basically an EMTALA exception in your ban. And a federal judge said yes, and granted a preliminary injunction to that effect. So most of Idaho's ban is in effect, but just that exception is not. So even when they do something really big, fast, seems overnight and important like that, it's still ocean liner like. But when you think about it, you've got these nine captains who all think they're the captain and are all independent captains, and then one changes. And then another one changes, then another one changes. It takes a while to figure out. And remembering, like, while it might have been that abortion was key for Trump's 3 appointees, there are 1,000 other issues. And you need to figure out what you think, especially if you've not been an appeals court judge for a long time, like Amy Coney Barrett. Even if you have been for a long time, it takes some time to figure it out. And then just think about for you working in your department, for anybody else working at your job, these are people who come into work on the first day and are basically told you're going to have basically the same coworkers for the rest of your life. Like they might change one by one over the decades, but like for the next 20 to 30 years, like it's you with these people. And so sometimes they're thinking about cases very differently than us. Like we are worried about this case. One, they are worried about the law writ large and what the effect will be on the country, on other laws. But like, honestly, they're also thinking about their colleagues. Like there might be times when like, and we see this when the justices' papers come out, where like you don't really agree with something, but like there was something in Justice Stevens' papers where like O'Connor writes him a note and is like, I would join your opinion if you like, I forget if it was add this or get rid of this. Like, and he writes back like, you drive a hard bargain, Sandy, but I'll do it. And it's like, neither of them, like, it's clear that she didn't really agree with all of it. And it's clear that he wouldn't have put in her thing, but like they did. And that then became the law of the land because it was the majority opinion. And that's something, one, that we didn't know about for 25 years, but also that like you would have no idea at the time of the decision. And so it's just, it's really interesting to watch as they get to know each other. And I think that there was some real, I mean, one, some views that Dobbs like tanked their opinion and should have. And I think that the liberal justices were like, you got what you deserved. Like the Supreme Court should take a hit from this because what you did was wrong. And then I think the debate internally, like forgetting what happened externally, I think the debate internally over the ethics code really put a damper on things. I think that like whenever you start seeing justices making out of court statements about the other justices, whether it's like about the court in general, but when it's about like, not when it's like, I love the court and it's great to do this important thing. You all know like the generic things that a justice would say. But when they talk about like, we expect that we're going to have something, like the justices don't talk about what they're doing in public. And so when they start doing that, you know something serious is happening behind the scenes. And so I think that like part of it was like, we finally got this done. Even if all of us outside can be like, oh, this is like, it's not enforceable. It's not harsh standards. They've even given themselves some more exceptions than other judges. But like for them, at least like that big critical internal fight, they got through it. I think the other thing, and we shouldn't understate this, is like they went through the pandemic too. Like they had 2 years without in-person arguments. And it is very like they did Zoom, they did questioning, they had counsel, but it is different. And like it does, I mean, think about like, I think there is an element to like the collegiality of the court that like it's a lot easier to be nasty. I mean, when you think about like any of you who study the internet, or like it's a lot easier to be nasty to someone on the internet. Like it's a lot easier to like get ground into a position opposing somebody when you're like not in the cafeteria with them every day.
Right. Maria, do we have a little time for Q&A?
We absolutely do. Dorothy, do you want to jump back in here and go back to what you were talking about?
It's not, I'm trying to remember what, oh, I know. Well, first of all, that Colorado lower court judge was female, not a male.
Oh.
And
yeah, I said they at one point because I realized I didn't know.
Well, and in her ruling, she declared that Trump did incite.
Yeah.
And,
Oh, yeah.
So in a sense, he, at least by that one judge, he was found guilty of insurrection or inciting the insurrection. So I don't know whether that will make any difference as the case goes forward, but anyway.
Anyone else have any questions?
There's a few other states that are petitioning that as well, too. Isn't there 4 states or 6 states trying to keep him off the ballot using the 14th Amendment?
Yeah, there are some other, I mean, they're not in the same position as the Colorado case. I mean, there are some where like the Secretary of State has like ruled it out on its face, and so they would have to sue the Secretary of State. And I think everybody agrees this Colorado Supreme Court case is the one that is going to be fastest moving.
Mm-hmm.
Chris, I'll ask you, it's not a Supreme Court case, but in these cases where some of these fake or alleged fake electors are getting charged, what do you legally, how do you see something like that unfolding?
I mean, they're fake electors. We don't need to, the question of whether or not they can be charged is a separate thing, but like they're not real electors. They met, like the Georgia case, I think it was, they like met in a side room. Like they even realized like, oh, we need to go to the Capitol. I forget if it was Georgia or Michigan, where they were like, we need to go to the Capitol. So they went to a side room and like said, like, let's not let people know why we're here. I mean, so they were well aware that they were fake electors, and like the distinction between like I forget when it was, but there was like a situation where there was an alternative slate of electors, I think in Hawaii, and that was because there were ongoing court cases, and so there was a decision to get a slate of electors ready in case the court ruled in favor of that candidate. I think that those are fair. Like at the end of the day, those are fairly straightforward cases. There's a reason why so many people are pleading guilty in Georgia. A lot of these cases, if it weren't Donald Trump involved, a lot of these cases legally are not complex cases. If it weren't, other than the DC Circuit, not DC Circuit yet, but other than the DC federal case, which just involves some novel applications of laws, like these are not the Mar-a-Lago case about documents is a normal case, and the federal the lower charges, the charges against other people in the Georgia case, the Michigan charges, I think it was it Nevada this week that they said that a grand jury was impaneled. I've been like so deep in Supreme Court stuff this week, but like, I mean, I think those are fairly straightforward cases. If you show that, I mean, it's when they sent things to like the archives for filing, like you're what you're doing is not real. It would be like me like sending something to like a state Supreme Court that's like my bar license from New York. I don't have a bar license in New York. I have a bar license from Ohio. Like it's just not a real thing. It doesn't matter if I get like a lawyer friend who signs a document and says that I am it and then certifies it.
one last thing for you. I mean, probably some of what he does could, who knows, end up with the Supreme Court, depending on how the cases go. But Jack Smith, obviously, he sort of operates in the shadows, which is where you would want him to operate. What is your take on how he fits into all of this? Because it's all intertwined.
Yeah, I mean, he's independent counsel, special counsel, not independent counsel, special counsel, and he is going to be running the DC case and the Mar-a-Lago case, but he, like, ultimate decision-making authority still vests with the Attorney General. So Merrick Garland signed off on those charges. And I think that I mean, the man's worked in The Hague. I mean, he's not afraid of Donald Trump. Like, he is going to do his job and is going to keep moving forward. Now, I am more naturally on the defense side of things. And so I do think that, like, these questions that the DC Circuit was asking about the effect of this case on other people is important, because we don't want one very bad man to create law that is bad for ordinary criminal defendants going forward, because we know that those bad precedents are going to be used against people who don't have the power that Trump has. And so I do think it's important to always remember that we've got a system. I mean, again, like I said, the Senate should have taken care of this, but we've got a system that is working. He has been charged. They are moving forward, at least in DC, even if Eileen Cannon is doing her best to slow things down in Florida. But it is going forward, and that's what the system can do. But I mean, I think being careful that we don't allow the stopping of Trump through court to be erosion of rights for other people in the future is an important thing to remember.
Thank you, Chris. And thank you, Michael, for handling this, and everyone who attended. We are streaming live on Facebook. It will also be up on YouTube. As the song says, what a time to be alive. So
Thank you, Chris.
Thank you so much, Maria.
You certainly
Michael,
are going
else.
to be very busy, Chris. Before I end the video, tell people how to find you with Law Dork. This is the time to promote yourself.
You can just Google away. That'll be the easiest. But it's just www.lawdork.com. And I am on all of the various social media we now have, pretty much everywhere as Chris Geidner and Law Dork News, on Twitter and Blue Sky and Instagram.
Thank you, Chris. And I will
Thanks
I will give a shout of endorsement to that. I am a subscriber. It's what I think it was $65 a year. It's something in that ballpark.
$60 a year, $6 a month, but there's also a free option too. But I do appreciate paid subscribers, because this is my job.
It is well worth it. It is detailed. It is a vital service at a time when newspaper coverage is just in decline, as we know. So thank you, Chris, for taking your time. I know you're busy. I don't know when you sleep, based on how many emails I get coming from your Substack. So I'm like, this man does not sleep. So
I sleep. Don't worry.
Okay.
When I don't have the Supreme Court, I sleep in.
All right,
I'm
perfect.
not a morning person.
Thank you, Chris. I'm going to end the live video now, and thank you again for taking the time. We so appreciate you.
Thank you, Chris.